Good afternoon, everyone. Welcome to today's seminar that is brought to you via the Transformation Office as part of its Equality Promotion and Social Inclusion project, which is centered around advancing equality and dismantling any forms of barriers to social inclusion, as well as discrimination within our university space and beyond. So it's a space for engagement. Thank you so much for making the time to join today's seminar, as well as to those who will be watching via Facebook live stream. Today's seminar is titled The Regression of Refugee Law in South Africa, and our guest speaker is Molia Vundamena, and she is a researcher and a PhD candidate in public law, specializing in refugee law. So she is quite well-versed in this particular topic. So without further ado, I will hand over to Molia to start off today's presentation. At the end, we will have time for questions, and Molia will then answer those questions. Please feel free to either use the chat function or to raise your hand and unmute and ask the question directly. So thank you so much once again for joining, Molia. The floor is yours.
Good afternoon, everyone. Thank you so much for that wonderful introduction, Adelaide. And also, I'm so honored to be here to share my research with everyone. I hope you will find it useful and informative. So today's presentation is based on my original research that I conducted during my master's program. My dissertation was entitled An Empirical Study of Unfair Discrimination Against Female Asylum Seekers. The aim of my study was to investigate the level of protection, rights, and entitlements that state parties to the UN Refugee Convention are obliged to offer to female asylum seekers in terms of international, regional treaty laws, and particularly with regards to the fair and equal treatment and protection from violence. According to the UNHCR, more than 30 million people are refugees and asylum seekers who fled their home countries. This also includes people who are in refugee-like situations. The United Nations Convention relating to the status of refugees, which we shorten as the UN Refugee Convention, and the OAU Convention governing the specific aspects of refugee problems in Africa, which we just call the OAU Refugee Convention, defines a refugee as a person who, owing to a well-founded fear of being persecuted for the reasons of race, religion, nationality, membership to a particular social group, or political opinion, is outside his or her country of origin and does not have the protection of his or her state. And that person is unwilling to return to the country, or they're unable to return to their country. Article 1A2 of the convention, the UN Convention, is your primary source for that. So it's important to define people in refugee-like situations. So these are the people who are outside their country or territory of origin and who face protection risks similar to those of refugees, but for whom refugee status has not been ascertained. South Africa is under obligation to protect refugees and asylum seekers. The Refugee Act was promulgated in 1998, while South Africa was still a young democratic state. The Act has undergone several amendments. Some of them have been viewed as a curtailment of refugee rights and freedoms due to the strict rules and the unconstitutional nature. The study that I conducted, I interviewed female asylum seekers and refugees, and I conducted the study in 2020, between 2020 and 2021. So the study revealed challenges and the challenges that can be associated with the limitation of refugee rights. Initially, 2 studies were conducted. The first was with female and male asylum seekers and refugees. In total, there were 25 participants, 14 male and 11 female. My apologies, 14 female and 11 male. This was to obtain a representative sample of the experiences and perspectives of both male and female asylum seekers and refugees living in South Africa. The second study was with persons who work with refugees and asylum seekers in Port Elizabeth and in Cape Town. There were 7 of them in total. Their responses helped identify the challenges, opportunities, and gaps that were present in the current delivery of services to refugees and asylum seekers. This slide just shows some of the biographical information of the participants. The majority of them were from Burundi, and I had 1 participant from Gabon. The youngest participant was 18 years old, and the oldest was 60 at the time of the study. The study included individuals with asylum permits, refugee permits, Zimbabwe exemption permits, and permanent residence. The number of years that the participants had lived outside their countries of origin varied from 1 year to over 40 years. The majority of the participants had lived in exile between 10 years and 20 years. So here, the slide highlights the reasons why participants fled their home countries. All the participants cited either war, political tensions, and instability, mass killings, or genocide in their countries of nationality. The female respondents specifically mentioned gender-based violence, sexual violence, rape, and fear of being victims of these horrible acts. As you can imagine, they faced several challenges when fleeing their countries, including transportation challenges, and they lacked food and shelter. They had trouble crossing the borders when leaving their countries of origin and when entering South Africa. So they often hid in cargo or used dangerous routes to get across the borders. So the main aim of the study was to investigate the participants' experiences when accessing several rights and entitlements, including healthcare, sexual and reproductive healthcare, education and training, employment, access to food, clean water, shelter, housing, and we also looked at their rights to freedom, safety, and security. So when it comes to healthcare, refugees initially praised the healthcare system in South Africa, but they had encountered challenges with the medical personnel. Firstly, there was the issue of language barriers. Most asylum seekers cannot speak fluent English or any local South African languages, especially when they just arrive in South Africa. They also stated that the treatment they receive depends on the nurses and doctors on duty. Some nurses were kind to them, while others have a xenophobic attitude towards them. They recalled being called kwere, which is a very derogatory term for foreign nationals. Some medical personnel outright refused to treat them, or they deliberately delayed in administering treatment. Also, they said that they were charged exorbitant fees for medical treatment, and others recalled being the victims of verbal and physical abuse by the nurses. It's important to note, though, that all difficult situations don't amount to medical xenophobia, because even South African nationals report similar challenges at public healthcare institutions. So it's important to be fair regarding that. Regarding the educational opportunities, the participants highlighted that primary and secondary schooling is available to them, but they often can't access higher education due to the cost of tuition. All the respondents in Port Elizabeth cited the unavailability of bursaries, scholarships, and other sources of funding, even loans for further education or training. They also said that they didn't have the opportunity to pay fees in installments. On the other hand, the respondents in Cape Town and Joburg had more organizations available to help them. So they had easier access to funding opportunities. Regarding the right to work, out of the 25 participants, only 5 of them were in salaried employment. The majority of them were self-employed or they had started businesses. The challenges they had encountered in obtaining gainful employment included difficulty in getting valid immigration documentation. Employers rejected asylum seeker or refugee documentation. They said it wasn't valid. Their age was also an issue for those who were over their, who were in their 50s. For the women, they cited lack of childcare services. So they had to stay home and take care of their children because no one else would do it. Others cited discrimination. Again, the K word came up, kwere. And there were also language barriers. Here, the differences in PE and in the other 2 cities I mentioned, Cape Town and Joburg, were that with the organizations that are available there, when asylum seekers arrive, they're able to go for language classes and they start learning English and 1 or 2 local South African languages. So that eases them as they acclimate into the South African society. The participants also talked about the issue of their expired visas owing to the prolonged visa processing times and rejected visa applications that affected their livelihoods. When it comes to food, clean water, shelter, and housing, the participants mostly brought up financial difficulties due to lack of employment and business opportunities. They also talked about discrimination and harassment. Some of the women said that they had been sexually harassed by potential landlords who were only willing to lease them properties in exchange for sexual favors. And others also mentioned the lack of access to public services and corruption. So now getting to South Africa's refugee system. The South African refugee policy was previously a progressive one, if not the most progressive, one of the most progressive policies in the world. It included the basic principles of refugee protection. South Africa grants all persons within its territory, regardless of their immigration status, a particular set of fundamental human rights entrenched by international law and the Constitution. But according to South African refugee laws, refugees also have the rights of all non-citizens, which are usually the same rights as citizens. The rights granted explicitly to citizens are political rights. So that is the right to vote, stand for office, form a political party, the right to have a passport and a South African identity document. It's also important to note that the Constitution, much like international instruments, doesn't draw a distinction between non-citizens and citizens for most of the rights guaranteed by the Bill of Rights. So it grants, it guarantees the protection of internationally recognized human rights to refugees and migrants as well. Unfortunately, South Africa's government has implemented a steady curtailment of refugee rights and freedoms over the last decade or so. These are codified through the Refugees Amendment Act, which came into effect on 1st January 2020 and was very controversial. The Act introduced several sections and regulations, which included the removal of the right to work, and it introduced strict rules around exclusion from refugee protection. Previously, asylum seekers had an automatic right to work, but this policy has been withdrawn by the introduction of a provision that divides asylum applicants into two groups. There's those who can financially support themselves and their dependents for 4 months, and those who cannot. The individuals who can support themselves within that period are not automatically entitled to work during these 4 months, and they must seek assistance from other organizations. Now, this is worrying because majority of asylum seekers often flee with only the clothes that they have on, and they use many modes of transport, including hitchhiking and walking, which indicates that they don't have the financial means to support themselves. And looking at the framework in cities such as Port Elizabeth, the only help that they could get was from the Refugee Rights Center. And it's mostly there to help them with legal matters, even though sometimes they do provide different services. So at the end of the day, refugees in the Eastern Cape tend to cater for themselves, and they basically feel abandoned. Some of them actually said that they regret going to Port Elizabeth and wish that they could go back to the refugee camps where they were able to at least provide for their children. The amendments also expanded the reasons why refugee status could be withdrawn. These include committing a Schedule 2 crime, like entering the country illegally, or committing an offense related to fraudulently obtaining ID documents. This rule is in direct conflict with international refugee law, which prohibits the penalization of refugees for irregular entry into the Republic. Secondly, an asylum claim will be considered abandoned if an asylum seeker does not attend a refugee reception office within a month from the date of expiry of their permits, unless they have a compelling reason for the delay. This is also challenging because if you've been following the news, you see that there has been massive backlogs, and most asylum seekers stated that they would stand in a queue from as early as 3 or 4 a.m. in the morning, and they wouldn't even be helped that day. So they end up spending several days at the RROs trying to get their permits renewed or trying to be recognized as an asylum seeker. And the last problem is that asylum applicants need to lodge an application within 5 days after arriving in South Africa, or else they face exclusion from refugee protection. Here, it's important to highlight that these conditions conflict with the principle of non-refoulement and the court judgments that support refugee law in South Africa. This slide is showing, it's highlighting the irregular movements that refugees make when they're moving to their countries of origin. So this is a story of 3 respondents who participated in my study. We will call them respondents F1, F2, and F3. They are all from the same family. It's a mother and her 2 daughters. So F1 was the mother, and she had 4 children. F1's husband had been a member of the opposition in Burundi, and he had fled to South Africa a couple of years before them because his life was in danger. F1 and F2 were being monitored and harassed, so they feared for their safety and they decided to leave Burundi. They left Burundi in early 2011. From Burundi, as you can see, they traveled to Tanzania. They got on a bus to there. And then from Tanzania, they got on a bus to Zambia. Unfortunately, in Zambia, they were arrested and detained for about 2.5 weeks for illegal entry. They were first detained in a jail and then later transferred to a prison. After that, they were deported to the Democratic Republic of Congo because most of the detainees were Congolese. So no refugee determination processes were followed here. The family spent 1 month in Congo before they were able to cross back into Zambia, and then they hitchhiked to Namibia. In Namibia, they spent 4 months before a truck driver offered to take only 2 of the children into South Africa. A respondent F1 sent respondent F2, who was around 10 or 11 at the time, with her younger brother who was 5 years old, with the driver to travel to South Africa and look for their father. On the second night or so, the driver tried to rape respondent F2, demanding payment for transportation to South Africa. It took respondent F1 and her other 2 children another 3 or 4 months to arrive in South Africa. During their journey, F1 and her children lacked shelter, food, clothing, and other basic necessities. Overall, it took these respondents almost a year to travel from their country of origin to South Africa. So this example just illustrates the irregular movements that they make and some of the hardships that they face during their travels. It's a well-known fact that refugees often have justifiable reasons for illegal or irregular movement into countries. This includes traveling without an identity document. So it's upon the countries to ensure that immigration provisions do not impose unrealistic demands or expectations regarding the quantity and the quality of identification documents or entry into these countries. The refugee determination processes are very important in assessing the plausibility of the explanations provided by the asylum seekers. So this assessment must be done on a case-by-case basis. Unfortunately, detention is neither expressly prohibited under international law, nor is the right to liberty absolute. The detention of refugees and asylum seekers is permitted as an exceptional measure and can only be for a justified legitimate purpose, like public health, in the interest of public order and national security. Section 22, subsections 12 and 13 of the Amendment Act state that failure to renew an asylum seeker permit within 1 month of expiry now results in a claim being deemed abandoned, a forfeiture of the right to renewal, and results in treatment as an illegal foreigner under the Immigration Act of 2017. Also, asylum applicants must lodge an application within 5 days after arriving in South Africa or face exclusion from refugee protection. So as I previously mentioned, with the backlogs and lack of assistance, these timeframes put asylum seekers in a difficult position because they're unfair and they're very impractical in their very nature. You have to consider the long traveling distances, the long queues at the Home Affairs offices, staff capacity constraints, and corruption at the refugee reception centers. So these practical and financial difficulties faced when accessing or renewing asylum and refugee permits forces asylum seekers into undocumented status, and this eventually puts them at risk of expulsion. Also, these rules contradict the principle of non-refoulement because a person can be labeled as undesirable and deported, and they will face the dangers that they were fleeing initially. These cases are important in refugee law because they confirm that asylum seekers cannot be denied on the grounds of delay. And they also asserted the principle of non-refoulement. This is an image of a notice that was put up at the Home Affairs offices in PE. On the face of it, it does have a xenophobic element to it. But if there is a justifiable reason for this, it hasn't yet been given. So from the notice, you can see that it simply states that the issuing of green barcoded IDs for permanent resident permit holders and naturalized RSA citizens has been discontinued in this office. So people have to travel to one of these cities in order to get their IDs renewed. So you can imagine the cost that will be incurred here, aside from the traveling time, the traveling time and the financial aspects of it. It affects a lot of asylum seekers and refugees, and also the permanent residents here, because they will have to take time off work, or they'll have to leave their businesses and their families just so that they can get their IDs renewed. So here I'd just like to emphasize the actual principle of non-refoulement. It is the underlying principle of refugee law. So the possibilities of expulsions or deportations are the main reason why we say that there has been a regression of refugee law in South Africa. This principle of non-refoulement is being undermined, and the term is rooted in the French word refouler, which means to drive back or to repel. So this is the principle that obliges states to refrain from forcibly returning a refugee to a state where he or she is likely to suffer persecution, danger to life, or unlawful danger to freedom. It is a customary international law rule, which was codified under Article 33(1) of the UN Refugee Convention, and it has been recognized by South African courts as a rule of customary international law. This means that South Africa is bound to this rule. It is an exception to the international law rule, which provides that because of the inherent sovereignty that every state has, they have the right to forbid the entrance of foreigners into their territories or admit foreigners other than in circumstances that they deem fit. So it supersedes the territorial sovereignty principle, or at least it's supposed to, but it's not an absolute rule, and it's also subject to some limitations. The UN Refugee Convention does provide a disclaimer for this, and it says that this principle may not be claimed by a refugee if there are reasonable grounds for regarding that the refugee is a danger to the security of the country in which he or she is, or if the person who has been convicted of a final judgment of a particularly serious crime constitutes a danger to the community or that country. The confusion that this raises now is, what is a particularly serious crime? Because this hasn't actually been well defined. So it's actually very possible for a refugee's country of origin to claim that this person has committed a crime, when in fact, that person was just enforcing their rights. So it somehow provides a loophole. That's the unfortunate part here. This exception is also carried into the South African Refugees Act in Section 4, which sets out the exclusions to refugee status. There is a close nexus between the current refugee policies and the number of expulsions that will result from this. So if you've been following the news, you can see some of the challenges that the ZEP permit holders are having. So this is one of the results of that as well. So in a nutshell, the strict rules and reasons for withdrawal or exclusion from refugee status are unworkable because of the impracticalities of obtaining or renewing documents. These challenges contribute to the number of undocumented individuals, or those labeled as undesirable, and that also results in the risk of deportation or expulsion from the Republic. In the refugee setting, the deportation or exclusion is not a standalone action. It is linked to the right of the person not to be persecuted or subjected to some form of torture or cruel, inhuman, and unusual or degrading treatment if they are compelled to return to their countries of origin, all of which conflict with the Constitution. These amendments may be construed as an indirect method of forcing asylum seekers and refugees to leave the country, and they violate customary international law principle of non-refoulement. So the current policies regarding refugees in South Africa needs to be revised, keeping the principle of non-refoulement at the core. This slide is just showing some recent developments. Some of the amendments, the provisions in the Refugees Act, the Refugees Amendment Act, were challenged by the Scalabrini Center. The good news is that the High Court declared sections of the Refugees Act unconstitutional as recently as last month. But even though they have been declared unconstitutional, the changes won't take place immediately. We have to remember that even though a law has been struck down by the High Court, or even if it gets to the Constitutional Court, the changes have to be promulgated by Parliament. So the changes won't take effect immediately. Some of these challenges might still be encountered for the next 2 to 3 years. So to conclude my presentation today, I'm just going to highlight some of my findings from my study. So the first is that the responses from the refugees and asylum seekers corresponded with those of the service providers in terms of the overall opportunities and challenges identified. There were incidences of unfair discrimination against female and male asylum seekers and refugees alike. But it wasn't, some of them weren't specific to females only. Xenophobic violence and xenophobic attitudes against refugees and asylum seekers in South Africa are the root cause of the violations of the rights of their human rights. There is also a need for social cohesion programs and inclusion in communities. This was evidenced by one of my participants. She was both a refugee and she worked at a refugee service organization. And she highlighted that in one of the areas where they were working, they had programs where they would interact with South African nationals and they would tell them their stories. And the result of that was that the South African nationals understood the plight of refugees and it brought the community together. So that was the testimony of the importance of social cohesion programs. Another one was for the youngest participant who had been in high school. When she initially arrived in South Africa, she was called names. She was called Kwekere as well by both students and teachers. But as time went along for her, some of them started to know her story and they understood why she left her country. And their mindset towards her actually changed. Their mindset towards refugees, for some of her classmates anyway, their mindset changed and they were more welcoming and they embraced her as part of their community. The next finding is that South Africa's current laws and policies are discriminatory and regressive, particularly concerning labor and hiring practices. The current refugee laws have the effect of unfairly discriminating against female asylum seekers owing to their inherent vulnerability. That means that because they're women and they're in a refugee situation, it exasperates any situation that they may be facing. This can be seen from the example of them trying to get jobs, or even the little girl who was almost raped as she was trying to travel to South Africa. So using the Hartson versus Lane test, most of the laws and policies in place do not have a legal justification in terms of Section 36 of the Constitution, in that they do not have a legitimate purpose. There is a lack of refugee aid organizations in Port Elizabeth. Hence, there is a great need for their establishment or an expansion of their mandates. It's important to note that the emergence of aid organizations is dependent on their intended output within a certain field. So that was why I mentioned the Refugee Rights Center being a legal organization and it not being fair to totally put it on them to cater to all the refugee needs in the city. There is difficulty obtaining documentation, and it's affecting access to most human rights. It's leading to the increased number of undocumented migrants in the Republic. So most asylum seekers opt out of renewing their papers due to the exorbitant and frequent costs associated with renewing documentation. Regarding this point, that was where the asylum seekers pointed out that they kept on renewing documents, and some asylum seeker permits were for as short as 1 month. So every few weeks, they had to renew their permits. And lastly, religion and culture are often impediments to women accessing the most basic human rights and necessities. So this raised issues of reporting GBV, sexual and reproductive health rights, employment, education, and training. Some participants here actually admitted that because of their cultural beliefs, they couldn't report cases of GBV to the police, and they just had to live with some of these challenges, and they had to suffer in silence. And finally, the recommendations that I had in my study were that social cohesion programs are important. They assist in building relationships between refugees and migrants and South African nationals. There's a need for programs to inform asylum seekers and refugees, as well as service providers and other key population groups about the rights and entitlements of refugees and asylum seekers. The Department of Labor needs to revise its regulations to have less stringent requirements that would allow more asylum seekers and refugees to enter formal employment. There needs to be a revision of current policies regarding refugees in South Africa. And lastly, there needs to be more empowerment programs for women, particularly in PE, to assist those with little to no formal educational background to learn skills, learn about their rights, and eventually become self-sufficient. So that brings me to the end of today's talk. I'd just like to say thank you for attending, and thank you all for your attention. I will hand over to Adelaide to see if there are any questions.
Thank you so much, Molia, for that. It was very insightful. Definitely looking at, the unfair discrimination that is associated with refugees and asylum seekers. It's definitely something that is very topical at the moment. You did make reference to the ZTP, which is definitely a big issue at the moment, and I guess the struggles that those particular permit holders are facing now that they have been directed to apply for mainstream visas, and I guess most of them won't even qualify for those mainstream visas. So this whole issue that there might be a big problem on our hands regarding undocumented migrants in that particular instance, or deportation. I think they're looking at numbers of 120,000 plus people at stake at the moment. So thank you so much for that insightful presentation. We'll open the floor now to questions. Please feel free to use the chat function or to unmute and ask your questions directly. I think from the chat, there is a question that says, is there any legal protection for economic refugees? And then from Facebook, there was a question for you to kindly go over the different categories of refugees or asylum seekers, if they are. So those are the two questions at the moment. And then there's a comment from Rachel that says, very informative talk, really enjoyed it. So yeah, I think you can take those two questions for now. Molia, if there are any other ones, please feel free to pose those.
Okay, thank you so much, Adelaide. So when it comes to economic refugees, it's a very tricky situation because when it comes to refugee law, there are specific reasons why a person will be recognized as a refugee. And those are the 5 listed grounds. That's race, religion, nationality, membership to a particular social group, and political opinion. But in some countries, economic refugees might actually have a loophole if they can prove that their claim falls under a membership of a particular social group, though it's very tricky. But ultimately, you'd have to prove that there is direct danger. And also in that light, I would like to point to the environmental aspect of that, to say that there are situations that are arising where environmental factors are posing a threat to people. So there's a recent Bangladeshi case. I think we'll be able to share the slides, right, Adelaide?
Yes, you can. I think you can share them via the chat. I think there should be a function to do that. If not, you can email me the slides to me and I can share them afterwards.
Okay, thank you. So there is a case where a Bangladeshi man was actually granted asylum in France on the basis that he could not return to Bangladesh due to the environmental factors there. So there is, well, the field of refugee law, there are certain expansions that you can notice from that. But there are very slim chances. So you have to find other ways of getting your claim approved. In that light, in GBV cases are also being recognized under refugee protection. So I think it depends on the country that you're in as well. What was the second question?
Thanks for that, Mo. The second question was for you to go over the different categories of refugees or asylum seekers, if there are any.
I wouldn't say they are actually categories of asylum seekers. It's mostly just based on their claims, but officially recognized, there are no officially recognized categories. But the claims that are being approved, you can find that people are being approved for, as I mentioned before, economic factors. And the link with the economic factors were, back to the first question, because everything ends up being interlinked in this field. So you have to link the economic factors to being a reason for political instability, and that will fall under persecution or another listed ground. But you can talk about them leaving because of persecution. You can talk about gender-based violence. You can also include forced marriage that has also been accepted as a valid refugee claim, and also harmful cultural practices such as female genital cutting. So I don't know if that answers the question, but it's all looked at on a case-by-case basis.
Thanks for that, Mo. I think that definitely answers it, specifically because you took us back to the listed grounds or the listed factors. Are there any other questions in the room? I think I'll just pose one maybe as a food for thought, Mo. With the current situation in South Africa as it stands, I know there have been several comments about the competition of resources and the need to put South Africans first. So looking at the changes that we have in refugee law, maybe let's look at employment, for instance. With the rate of unemployment that sits in South Africa as it stands, would then that be regarded as a justification then for having these amendments? The fact that the current situation in South Africa, there's huge unemployment, there's maybe a shortage of resources or a competition for resources. So with that being said, we are prioritizing South Africans. So unfortunately, asylum seekers or refugees are not then at the top of the food chain with regards to consideration in that moment. Would you then say that that would suffice in terms of Section 36?
In terms of 36, I would say no, not really. Because by excluding them, the South African government doesn't actually realize that they are substantially affecting their economy. If you look at the most developed countries, you look at the USA, for example, they pride themselves on being built on the back of migrants, and they're welcoming to migrants. And I think that the perspective of saying we're only going to look at South Africans, or we're only going to put at South African nationals first, I think that it is going to do an injustice for the country as a whole. That's my personal opinion. And also, we have to look at progressive realization of human rights in South Africa. It has to be a slow process. We understand that not everyone's rights will be realized, not everyone will be able to access the same things at the same time, but we have to keep that in mind. So I don't think the exclusions are justified in any way. I think that they just have to take their time. Another thing that will be affected will be, for example, in the sphere of medical care. I read a study recently that stated that a significant portion of medical personnel, South African medical personnel, have migrated to developed countries. So most of them have migrated to Europe and Australia and the USA. And there's a significant number of healthcare workers in South Africa who are not South African nationals. So when you start looking at things from that perspective, you start to realize that it's actually going to affect the country as a whole. Because once you tell them to go back to their countries, you're going to have a shortfall of skilled labor in the country as well. It's going to affect it.
Okay, thank you so much for that, Mo. As I said, it's a very difficult space to be in. As I said, now we're already seeing the tensions surrounding this, especially coming to fold with the ZTP and the fact that it is set to expire just before election season in Zimbabwe. And we know, based on previous history, the political tensions that kind of underlie the elections in Zimbabwe. So it is a very trying situation to send people back during that particular time frame. As you mentioned, political instability or political persecution is one of the grounds. So that becomes very interesting how that will play out. But yeah, it's to be seen, and we will let I guess the legal processes take their place. But thank you so much for your presentation today, Moya. We really enjoyed it, and we learned a lot. I speak on my behalf and the behalf of everyone that has joined, including via Facebook live stream. Thank you so much once again for overcoming the technical difficulties that you had in the beginning, and sharing your research and your knowledge with us. And we hope you will come back into the space and continue to update us. To everyone, I wish you a happy Human Rights Month, and please do enjoy the rest of your afternoon. Bye.
Thank you so much. Bye.